5 seconds to go. Start. It clearly provides that when a petition for recovery of possession is filed in respect of premises or tenancy to which Chapter 2 to 4 of the Act of 2001 do not apply, the time schedule and procedure prescribed under Section 18 of the Act of 2001 would apply. Hence, it is crystal clear that a petition for recovery of possession can be filed in case of any other premise or tenancy which is not governed by Chapter 2 to 4 of the Act of 2001. If the intention of legislature was to confine jurisdiction of rent tribunal to the cases governed by clauses A to M of Section 9 of the Act of 2001 only, then there was no occasion for inserting subsection 3 in Section 18 of the Act of 2001. In the case in hands, as the lease was for a period of 11 years, it is not governed by Section 8 of the Act. Hence, Chapter 2 and 3 of the Act of 2001 are applicable. As a corollary of discussion foregoing, this court is of the considered view that jurisdiction of civil courts to deal with any matter, the case, or the dispute between the petitioner and respondent is required to be tried and decided by the rent tribunal only. My aforesaid view is fortified by the following judgments, relevant part whereof is reproduced hereinafter. Nalin Mehta versus SBI Supra, having given a thoughtful and anxious consideration to the rival submissions and having examined the scheme of the Act of 2001, this court is clearly of opinion that the impugned order proceeds on total misinterpretation of the plain provisions of law and cannot be sustained. The Rajasthan Rent Control Act 2001 is to the provide for control of eviction from letting off and rents for certain premises in the state of Rajasthan and matters incidental thereto. The Act has been divided in 7 chapters under the heads: Preliminary, Revision of Rent, Tenancy, Restoration of Possession of illegally evicted tenant and procedure thereof, Constitution of Tribunals, Procedure for Revision of Rent and Eviction, Appeal and Execution, Amenities, and Miscellaneous. Section 1 of the Act clearly provides that it extends in the first instance to such of the municipal areas which are comprising the district headquarters in the state, and later on to such of the other municipal areas having a population exceeding 50,000 as per 1991 census, as the state government may, by notification in the official gazette, would specify. Subsection 3 of Section 1 provides that this Act would come into force with effect from such date as may be appointed by the state government by notification in the official gazette. The state government has appointed first day of April 2003 as the date on which this act shall come into force, and it shall extend to all the municipal areas which are comprising the district headquarters. Stop.